Okay, well, thanks for that introduction, Bob. You
Is that
should see
you
a
running around
screen.
out there in the field?
My
Yeah, you're
screensaver.
on presentation mode, Roger.
There you go.
Okay, thanks very much. So this presentation is number 7 in a series of 12. And last month we talked about financings and we touched on the security. We did more of the terms and conditions of a financing, and we sort of touched on securities laws. This month we're just going to spend the entire presentation on securities laws. And oddly, we just don't see that very often. Everybody wants to talk about, what all the terms are and what they mean, and nobody spends enough time on securities laws. So this is probably the first time we've done a topic that's really just highly regulated. We're on an area of law that's just very highly regulated. And I was thinking about this driving into work this morning. So many years ago, when I was living back in North Dakota, one summer I had occasion. I was on my way driving down to Texas to visit someone I know, and I was going through this small town. I was on Highway 81 south. I went through this small town in northern Nebraska, and I was pulled up to a stoplight, and I'm sitting there and tap 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 on my window, and I look up, and here's this deputy sheriff. And I roll it down. I said, but back then you had to roll it like this, you didn't have automatic windows. I said, what's up? And he says, yeah, he says, you're speeding. He says, I clocked you with a stopwatch for Pete's sake. And I said, well, I don't think so. I'm sitting at a stoplight. How can I be speeding? He says, oh no, I clocked you. And I said, well, now what? I'm going to give you a ticket, and you could just pay it here, or you can come on down to the courthouse and wait. And I said, well, I'm not going to pay a ticket. I wasn't speeding. I'm stopped, for Pete's sake. So we went on down to the sheriff's office, and he says, well, we'll just wait here for the sheriff. And we waited for a little while, and sheriff came in, and I remember he looked around and he says, so where's that guy who thinks that this is Indianapolis? And says, you and I are going to have a little talk about the law. Then he explained to me that if I didn't pay the ticket, I could sit around and wait for the judge, who comes through their town every week or two. We could decide it then. So he took all the money I had and sent me on my way. From then on, I did not go through that little town. Driving around. That's how it was back then. And I'm reminded of that because that's an example of regulation. And we've had a very tough sheriff in town up until recently, we'll say. And by sheriff, I mean the commissioner of the Securities and Exchange Commission. Now we got a different sheriff who's a little bit different. And I not only mean only the commissioner, but the laws themselves have been changing. So now is a good time to talk about securities laws. So first of all, usual disclaimer: this is not legal advice. This is just information. So your circumstances may vary. Consult a lawyer on specific questions. I'm going to talk about kind of a long list of things relating to the sale of securities. What is a security? I'm going to focus mostly on private offerings because this is startup law, which by definition for most of your life, if not all, is going to be private offering. Maybe some secondary sales. But we're just going to focus on the main laws that apply and why it's important and why you need to pay attention to it. So here is the basic rule of securities law. The federal rule is that every offer and sale of a security, it either has to be registered, that's an IPO, public offering, or exempt from registration. And like I say, in the private company space and the startup space, we rely very heavily on those exemptions. And we're going to talk mostly about the Securities Act in 1933. Yeah, that's right. It's almost 100 years old, which is designed to ensure transparency and protect investors from fraud. And when you think about these laws and how they're designed and the way they work, think about what this country was like in 1933. Before we had the 33 Act, I mean, pretty much any huckster, could sell you any brand of snake oil they wanted to without regulation. You could rely on common law fraud, but good luck with that. So it was that sort of environment that birthed the laws that we deal with today, but they have changed and are changing. So, like I said, every sale of security has to be exempt or registered. So that raises the question, what is a security? And I think anybody who went through the crypto boom of a few years ago is very familiar in the Howey test. And what's interesting about the Howey test is I learned about this in law school 100 years ago. And I thought that I would never, ever again hear about this in my life. And then in 2017, all of a sudden, everybody became a securities law expert and everybody wanted to talk about the Howey test because we had an instrument that is it a security or is it not? And that instrument was crypto. I'm going to talk about that more later. But let's just talk about the basic test. And this is not the only one. I'm going to talk about the other tests that are out there, but this is the main one that we all go to. And the idea is that a transaction is a security if it meets these four elements. There's an investment of money. There's a common enterprise. So you're putting money into a common enterprise. There's an expectation of profits, and that expectation is based on the effort of somebody else. And the exact facts of how we involved Orange Grove contracts, but this rule has been, as you can imagine, if you read it literally, it can be awfully expanded, and it has been expanded into areas that you never would have imagined, right? I mean, what if I buy into some sort of condo unit or something? So there's been a huge expansion of this, and I've used it over my career when I've wanted to classify something as a security, since it's such a broad, fuzzy test. So I also am not going to talk too much here about federal registration, but I did say exempt or registered. So let me tell you what I mean by registered. What I mean is here in the United States, federally, if we want to sell shares to the public, we file a registration statement with the Securities and Exchange Commission, SEC. It's typically a Form S1, doesn't have to be, there's other forms, but that's the usual one. And it has very, very detailed disclosures. And the idea is to solve this problem. Remember, 1933, to solve this problem of the asymmetry between what the company knows and what the investor knows. And we solve that asymmetry by just forcing just very expansive disclosures, financials, risks, the management, the business, the competition, just everything. Do you have precious metals? All this stuff. And then once declared effective by the SEC, the offering can proceed. And then the company has ongoing, you've probably heard about the 10Ks and 10Qs, ongoing quarterly and annual reporting requirements, as well as reporting of certain significant events. Not going to talk about that today. This is startup securities laws, but just mention that that's oftentimes the goal for most companies, is they want to get to that point where they can have a public offering and then they get liquidity and they can sell their shares out into the market, free of the restrictions on private sales and private offerings. Now, one thing to note about this that's kind of interesting is the United States, we register offerings, just blocks of securities. Other countries that do this, they don't necessarily do it that way. Sometimes you file and you just register the company. And now the company is free to provide whatever information it wants, or to sell securities because it's been registered. So, I don't know. I find that interesting. I'm going to talk more today about not the registration of securities, but the exemption from registration. And let me just summarize these, and then I'm going to say it again and again. So the first one, and the one that you will see most often, is what we call Regulation D. And under Regulation D, and this is Regulation D under the private offering exemption, and under Regulation D, there are some safe harbors. Rule 506B is by far and away what we rely on the most. And that is a private placement with no general solicitation. I'll talk more about what that means, but no advertising, no going through the phone book and calling people. No, I guess we don't have phone books anymore, but you get the idea. No skywriting. No general solicitation. Technically, we can take up to 35 non-accredited. I'll talk about why you don't want to do that in a minute. But private placements and no general solicitation, private placements to accredited, mostly accredited investors, and you've got a safe harbor. And why do we need a safe harbor? Because the general rule is that is section 4A2, which exempts transactions by an issuer not involving a public offering, which is a pretty fuzzy standard, pretty factual. So now we got the safe harbor, so we got a little more certainty. Rule 506C, which came into the law with the Jobs Act back in 2012, allows general solicitation, but all investors must be accredited. Okay, so we see that fairly often where a company says, look, we want to go on social media and tell the world what we're doing. So that's a general solicitation. Well, you can do that, but now all your investors have to be accredited. There's no wiggle room for non-accredited, and you have to verify that they're accredited. And then Rule 504, which I just don't do anymore. Early in my career, I did when I was representing yogurt shops that needed to take money from anybody. And since then, it's been expanded quite a bit. And mostly because it typically does require a lot of information. Reg A, we'll talk more about tier 1 and tier 2. This is like a mini public offering. It's where if you're willing to go and file a registration with the SEC and give them a lot of information, you can raise a lot of money, and it doesn't have to be from accredited only investors. It can be to the public and up to some fairly large amounts. Crowdfunding, which has really come along onto its own. In 2012, when the Jobs Act came along, we had crowdfunding, and every lawyer I know just hated it, because it was basically allowing widows and orphans to gamble their money. I don't know, they didn't hate Las Vegas or lotteries that much, so I don't know why they hated this, which is way less risky than blackjack, but they did, and everyone predicted it wouldn't stay around very long, but it has, and in fact, it has been expanded. And our regulations, I guess, is it C or CF now? Anyway, it allows offerings up to $5 million. Used to be 1 million, and it's through online platforms that are registered with the SEC or broker dealers. And the trick is that it's only, and it doesn't have to be accredited only, it's anybody. But the trick is it has to be small amounts of money. I'll get into that in a minute. You hear less about intrastate offerings. Companies theoretically can raise funds within a single state. In the internet age, how is that even possible? I don't know, but I've seen companies attempt to rely on this. 4A is the statutory exemption, not a safe harbor. And then finally, Rule 701, you might wonder, and we talked more about this during this series. We've talked about this during this series, but how is it that a company can give stock and options and securities to all of its employees who clearly are not accredited and you're clearly not public? And that's Rule 701. But Rule 701, again, comes with some strings attached as well. So that's what we're going to talk about. So let's start with 4A2, the Securities Act. That is the statutory provision that exempts from registration, again, transactions by an issuer not involving any public offering. And what is a public offering? Facts and circumstances, right? And that's why it makes us all so nervous. And sometimes, when somebody blows the safe harbors that I mentioned, and we'll talk more about, but they still need an exemption, and this is the one we're relying on. I guess we hold our nose and look the other way and find that there's no public offering. It's not something, and in fact, law firms will issue opinions under Section 4A2, even though it's a tough opinion, because it is very factual, especially these days when it is just so easy to publicly solicit and advertise. But it is out there and you should know about it. And then Reg D is the safe harbor under 4A2. And it's a set of rules that we had talked about. So let's kind of dive into it. So drilling down, again, Section 506B, safe harbor. This is the accredited only exemption, no solicitation. This is, if you're going to do a venture financing, it's going to be under 506B. If you're going to do an angel financing, if you're going to sell a safe, almost anything you do to raise money is likely going to be, most often is going to be under 506B. So it's an unlimited number of accredited investors, which I'm going to define in a minute, and up to 35 non-accredited but sophisticated investors. Well, what does that mean? That means they possess sufficient knowledge or they're advised by a representative. So, and California has a similar rule. And so sometimes we have, these non-accrediteds that the company, so the easiest way is to not let any non-accrediteds in, because how do you know if they're sophisticated? But sometimes the company just insists that the receptionist has to get some stock and their barber has to be able to buy in, and that people who are not accredited just have to have the opportunity to buy because they really need their $5,000 or whatever it is. Well, okay, are you sure they're sophisticated? So, have we given them enough information? And sometimes we will have to just go out and find them a representative to represent them, and it's financial, like a CPA or somebody, to represent their interests so that we can satisfy the sophistication requirement. So this is sometimes misunderstood, even by lawyers. This is misunderstood, the disclosure requirements. In an accredited only deal, there's no requirement to give them a PPM or a disclosure, not under Reg 506B. Now, there's things you want to tell them under the anti-fraud rules, but under 506B, no requirement that they get disclosures. Non-accrediteds, on the other hand, they do have to receive disclosures, and it's extensive. It's another reason you don't want to go this route. Company has to be available to answer questions. The company has to, okay, here's another one this is tricky. So the company is obligated to file a Form D notice with the SEC within 15 days after the first sale of securities. And there are real consequences if you don't do that, theoretically. As a practical matter, though, that Form D is public, and it discloses information about the investors that the company might not want disclosed, or the investor might not want disclosed. So oftentimes companies will just roll the dice, and I can't advise anybody not to file it, but I will tell you that oftentimes companies don't. Instead, they'll just comply with the state blue sky, which we'll talk about instead. So at least they don't violate those rules and they won't file the Form D. I think the better practice, I file Form D whenever I can, as much as I can. It's first of all, you can file it with the state, satisfy that requirement. And I don't have to worry about this fuzzy rule about, gee, do we have to file it or not? Restricted securities. We've recently gotten these bad actor disqualifications. In other words, you'll see this now on sales of securities. There's usually an attachment that says I'm not a bad actor, meaning, the SEC hasn't prohibited me from participating in the issuance of securities before. I haven't, violated laws, etc. And then restrictions, which we'll talk about, and that's a limitation on resale. And the purpose of the restrictions is you don't want somebody buying stock in a company and then going out and syndicating it. It's like they do the little old mini private offering, public offering, right? I'm a accredited investor. I buy stock in your company, and then I go sell it to 100 people who may or may not be. There's got to be restrictions on the resale. And the last thing I want to mention, and this is a really big concept in this area, is federal preemption. Federal preemption, there was a time when we didn't have that, and it was really just kind of a mess. But we've got this now. Where offerings are exempt, these offerings anyway, under 506B, are exempt from state registration. So in other words, the state can't require a separate registration if you meet this standard federally, because just think what a disaster that would be if we've got 50 states, right? So you're going to comply with the laws of 50 different states. It's hard to do. But the states can still require a notice, and they can charge a fee. And some states have kind of taken that to the limit. Mostly they're out in the East. And they require a pretty extensive notice and a pretty hefty fee, like $500. And sometimes because of that, I'll just tell my clients out here in the West, I'll say, don't even sell any to anybody living in this list of states. It's just not worth the trouble. All right. What is general solicitation, right? The thing that makes us work for accredited only is a prohibition on general solicitation. Okay, so that's, and the rule is stated here, public advertising or promoting and offering through a form of communication that reaches a broad audience. So what does that mean? Well, okay, obviously a newspaper ad. That's what people were thinking almost 100 years ago when these laws came up. But these days, it could be advertising on a website. It could be a television or a radio broadcast, or maybe a podcast, right? Or a social media post. We didn't have social media in 1933, or an email newsletter, mass mailings. And this is where people get in trouble. Seminars open to the public, because we have an exception for demo days, an exception if they're not open to the public. And with Zoom, I mean, what's open to the public anymore? Is this webinar open to the public? Right? Anybody can log in. So we've got those sorts of issues. Now let's talk about, I put this off too long. What is the accredited investor? Because everything kind of hinges on this. It's like once you meet this standard, it's just so much easier to get into deals. It's so much easier for the company to deal with you. Accredited investor for an individual. And by the way, the way you might think about it, an accredited investor is somebody who was rich in 1933, because these rules haven't changed very much since then. Okay, so that means somebody with annual income of over $200,000 a year, or $300,000 jointly in each of the last 2 years and expected in the current year. That's number one, income. Or net worth over $1 million, not including primary residence. That changed back in 2012 as well, because here in California, pretty much everybody has $1 million residence, either alone or with your spouse. And then there are other exemptions we don't rely on that often. The financial credentials, if you're a director or officer or general partner, you're a broker dealer. And then for private funds, there's a knowledgeable employee exception. Now, if you're an entity, there's really two ways that we qualify entities. Suppose we have an SPV, a special purpose vehicle that somebody put together to come invest in your company. Happens all the time. What makes that SPV, that special purpose vehicle, an accredited investor? Well, either it's got more than $5 million in assets, which is almost never the case, but okay, it could be. Or everybody in the entity is accredited, meaning we got to look through to all of the members. That's how it typically works.
Hello.
Hey, Bob, you're not on mute. There's been some proposed laws about accredited investor that I want to mention here, because like I say, new sheriff in town, new Congress, new Senate, right? New president. So there's some changes coming down the pike. And the one I really want to mention here is the Equal Opportunity for All Investors Act 2025, HR 3339, not law yet, but it has overwhelming bipartisan support. I don't know, Senator Warren will likely oppose it, but I can't imagine that many other senators or congressmen will. And it is and it would expand access to private investment by changing this definition. And the way it would expand access is by allowing individuals to pass an exam. Say, look, take this test, you pass this exam, and we're going to test you on financial sophistication, types of securities, disclosure requirements, corporate governance, financial statements. Do you understand risk? Do you understand conflicts? So this would be awesome, because then we don't have to guess whether somebody's sophisticated. No, they just pass this exam. So it's not yet law. It's been proposed. I hope it becomes law. One more way we can meet this. And if you think about it, it makes perfect sense, right? I mean, why were these laws enacted in the first place, right? Is it, I guess rich people can afford to lose money, yes, but also it's because of that information asymmetry, and which we presumably can solve by having sophisticated people invest in companies. And if, as an aside here, we've got this weird sort of dynamic in this country. It's schizophrenic. Um, I can get on a plane and go to Las Vegas. I don't have to do that. I can drive to casinos, and I can throw all my money away at a blackjack table. But if I want to, invest in a startup company, I got to pass all these rules. So it's weird. It's always has been weird, but it's getting less weird now if these laws pass. Okay, let's move on to 506C, another safe harbor, and this is an accredited only, but general solicitation is permitted. And this came in with the Jobs Act in 2012. And I'm going to tell you, this is huge. This is a sea change. And we saw, in fact, we are seeing online portals now, basically online venture capitalists who, or online angel groups that publish widely. They promote, they solicit, they publicize, but it's accredited only. And to make sure it's not a strict liability test, but the issuer has to take reasonable steps to verify. And it's a facts and circumstances type test, generally, but usually not many companies will self-certify. They'll ask for a third-party verification from a CPA. But you could, I mean, that's one way to verify. It's like, give me your tax return, right? Or your bank statement. And not many investors want to do that. So they'll just get their attorney or their advisor, or their CPA. And I've written those opinions myself to companies saying, yeah, this investor is accredited. I can verify that. Same Form D filing, same restrictions, same bad actor disqualification. Someone's been convicted of securities fraud. That's a bad actor disqualification from this safe harbor. Now, the interesting thing about this is that, yay, I got it, included the slide. We've had a recent change in this where let's make this even a little easier and a little more objective and a little less uncertainty in the process by saying, look, if someone can invest, an individual can put up $200,000 into a company, I think we can just assume that they're rich enough to be accredited, assuming we have no actual knowledge that they're not taking out their entire retirement fund, like they would in a catfishing scheme or something. But if we have no actual knowledge, we can just satisfy this verification requirement by the fact that it's at least a $200,000 minimum invested for individuals or $1 million for legal entities. Now, the investor, of course, has to make representations that they're accredited, and the investment is not financed by a third party. And this investment has to be a binding commitment. So this is another way we can satisfy this requirement. So this is getting easier and easier. And by the way, this is for the 506C type of offering where you have to verify. But I would say that this probably satisfies the 506B standard, which is a much lower standard. And if I didn't mention this, I'll mention it now. For 506B accredited only, no advertising, you just have to reasonably believe that the investor's accredited. And the way we reasonably believe it typically is by making them fill out a questionnaire. That's why you've seen investor suitability questionnaires. Or these days, we just have them make representations in the document that they're accredited. Well, this might be another way, I think, to satisfy that standard. It doesn't say that if it works for C, it works for B, but that would make sense. Okay, I want to mention that as a result, probably of the 2012 Jobs Act, we now have fundraising websites, and you know who I mean. And the SEC, these are old new action letters. I mean, it's been a while since I'm going to update this slide in a minute, but these are the old letters where the SEC has, and no action means that the SEC is determined they're not going to take action against somebody for violating some law. So here's a no action letter that says here, angel list. It matches investors with companies. Under that letter, it said, look, we're not going to take action because this is exclusively available only to accredited investors, and there's no transaction-based compensation. We'll talk about that in a minute too. Another no action letters, Funders Club, no action exclusively to accredited investors. Now, in 2012, the SEC did charge some companies because they were doing secondaries. It's like, well, gee, if we can use this online platform to buy stock in a company, how about we use this online platform to buy stock from somebody else who owns stock in a company? So we call that a secondary sale. And there was a flurry of activity in 2012. The biggest player in the market, Second Market, managed to, I guess I phrase it as escaped unscathed, but they had a pretty strict process. Now, on that point, this probably as good a place as any to talk about broker-dealer law, because this might be the next domino to fall in terms of new legislation, because this might be the most hated provision of the securities laws in Silicon Valley. And this is that pesky rule that prohibits you, the company, from using finders to go out and get money for you unless they are a registered broker-dealer. And that is a process. It requires a filing. It requires some qualification requirements. There's annual audit and reporting requirements. It's a hassle that nobody really wants to go through. And it's expensive. And broker-dealers tend to be more expensive because they've got more costs to cover. And this broker-dealer registration is mandatory, both federally and state as well. California has its own separate broker-dealer law, and we have a very aggressive bunch of regulators in California enforcing these laws. So it has to be taken seriously. And the biggest rule where it comes up, the biggest place it comes up, is with finders who want to take a percentage of the money that they raise. And as a general rule, so generally finders are not broker-dealers if they just make introductions. But the SEC says you are a broker-dealer if you're taking a percentage of money you raise. That's transaction-based compensation. And that's where we run into problems. And I know people do it anyway, and people argue with me ad nauseum about this. All I can do is tell you what the law is. I can tell you what the SEC says about it. And I can tell you that California is even tougher on this than the SEC. So it's not something that I'm willing to sign off on. And I don't really know a lawyer who is. Now, I will say that there have been proposals to lighten up on this. We've already got some loosening with regard to sales of assets in M&A transactions. Although, as an aside, we still have the California rules in that area, which they're not only complex, they're a little bit nonsensical. But anyway, getting back to this rule, the SEC has proposed two tiers to give relief from this. One, if you're just providing investor contact info, okay, that's tier one. There's another tier. Yeah, the finder can go solicit with some restrictions. It's only accredited investors are going to go solicit from. Not yet law, but as recently as this summer, the SEC has reconsidered this, and they're looking at this rule. So we might have an exception. And if there is anything at all in the securities laws that really needs to change, it is the broker-dealer rules, because I think they are far too restrictive. Okay, let's move on to Reg CF, regulation crowdfunding. And this is, remember what I said about crowdfunding? This is the Jobs Act, came in 2012, where companies could raise up to $1 million in a year through a crowdfunding portal. Over the years, that's been tinkered with and expanded. Now it's $5 million through an intermediary or a portal. The portal or the broker has to provide disclosures. They have to file, I guess it is Form C. I thought it was Form C. Have to follow Form C with the SEC, providing detailed financial and business information, including risk factors and terms of the offering. Depending on the size of the offering, they may have to provide audited statements. There are investment limits, and the securities, of course, are subject to a 1-year holding period. Again, you don't want people syndicating and doing secondaries. The investor limits that I mentioned, these tend to change, but I'll just to give you a sense, 5% of annual income or net worth across all Reg CF offerings, or 10% of annual income or net worth over a 12-month period. So you can take a look at the The investor limits, suffice it to say, it's smaller amounts, right? $2,500, right? I mean, they're small amounts. You go out to a big group of people. And because it's now, when this first came into effect, when it was only up to $1 million, my view was it's not worth it. You got to get audited statements sometimes. You have to file this document with the SEC. You have to, go pay 6% to some portal. The transaction costs are just too high. It's not worth it. Well, at $5 million, I'd say it is worth it. And it's gotten very popular. And I've seen a lot of companies raise money like this. And by the way, I've seen many companies now, because I'm going to ask all the VCs I know, hey, what if somebody crowdfunds and then they come to you for money? It's like, oh, no, I'm not going to put money in that. You've got, you're going to have 1,000 shareholders, which we view as potential plaintiffs. So we don't want to invest in that. Well, you know what they did? I've seen plenty of companies do a crowdfunding round and then do a venture round. And I've even seen a company do a venture round and then a crowdfunding round. Now, let me tell you what's loosened up to make this so attractive anymore. So this platform, of course, they have to be FINRA or SEC registered. There's some rules about using more than one intermediary and how much you can sell, who can be an intermediary, etc. I don't need to drill down in that too much because what I want to raise is the fact that these days we have a lot of things that make this way more attractive. We can do what we call testing the waters, right? Which means you go out and you let people know that you're thinking of doing this offering and solicit indications of interest. Couldn't do that before. We can have repurchase rights, provided that we specify really clearly what those repurchase rights are and how they work and when they work, et cetera. We made good disclosures. We can have special purpose vehicles. You can get a bunch of people pool their money together in a vehicle that makes, or you get a bunch of the crowdfunding investors in one vehicle. So you're not or maybe a proxy. So you're not dealing with 1,000 different people for a vote. You may be dealing with just one or one SPV or one we'll call it an escrow agent or something like that. The types of securities that can be sold under this could be common stock, could be preferred stock, could be convertibles, debt warrants, could even be a revenue share agreement. We talked about that last month. Most often these days, we're seeing what we call the crowd safe. We talked about safes last month. This is a special type of safe that is designed for crowdfunding offerings. So the market has really matured. It has really evolved, and this has become a very viable option anymore. And I'm not hearing a lot of lawyers just completely freak out whenever they hear crowdfunding. Briefly, because I talk about a lot about Reg A, but never do it once we do all the talking. So we used to have a Reg A that was like a mini public offering with the Jobs Act that came in quite a long time ago. We got Reg A Plus, they call it. And Reg A Plus means like a kinder, gentler Reg A. So tier one up to $20 million, but does not preempt state securities registration laws, which really you're not going to do it. If you can't preempt state law, you're not going to do it. The transaction costs would be too high. But tier two, that's a real thing. That's a maximum offerings, just went up to 75 million in a 12-month period. That does preempt state securities registration laws, so that lowers your transaction costs. You don't have to be accredited only. It's like a mini public offering. Now, the reason that we still don't do this very often is because it's like I say, it's a mini public offering. That doesn't mean there's no information requirement at all, because here's all the benefits. You can take non-accredited, right? You can take $75 million, you preempt state law. The downside is you do have to make a filing, right? You can test for interest, you can solicit, you can offer in public, but you do have disclosures, financial statements. You have to have a circular or a report. You have ongoing disclosures to your investors. So there's some burden around it. And a lot of times people might say, and plus these integration rules we have to comply with, and we'll talk about that in a second. So a lot of times companies will look at this and say, well, if we're going to go to all that trouble and all that expense, and it is an expensive process, let's just do a public offering. That's oftentimes where we come out because there are still hundreds of thousands of dollars of legal fees involved in doing a Reg A plus offering, at least. I have a really good chart in these slides that I can circulate that compare these three types of offerings. And we've kind of gone over everything already, so I won't restate it. I'll just say I've got a good chart, handy dandy chart you can take a look at. Okay, integration. So let's say I'm doing my 506B offering. That means I can't advertise. It's all accredited with a few non-accredited. But then at the same time, I'm doing a 506C. Can I do that? Generally, no, because the law will say, look, you're doing one offering. So we're gonna combine them to test whether you meet the requirements. But there are ways that you can do it without integrating the two offerings. The easiest way is if you separate them by 30 days. The other way is under the safe harbor rule 152. So we separate by 30 days. We have different types of securities with a very distinct investor base. We don't do a solicitation of one offering that benefits another offering. So I don't want to spend a lot of time on this, mostly just to let people know there is such a thing as integration, where you're doing one offering that would qualify. Say you're doing a 506B that would qualify. Well, all of a sudden you get that integrated with your 506C, right? So you've got a non-accredited in your 506B. If it gets integrated with the 506C, well, now you've got a non-accredited in a 506C and you blow the whole thing. That's integration. So these rules tell you how not to have that happen to you if you should have multiple offerings close in time together. Similarly, you might be doing a Reg CF, a crowdfunding, at the same time as you're doing a Reg D, right? Credited only with a Reg CF, which is mostly non-accredited. So again, we've got a safe harbor, and we've got some rules on how to clearly separate those two offerings so they don't get integrated. Something to think about. Now, I have to talk about blue sky laws. What blue sky laws mean, it's state securities laws. So every state is going to regulate what happens within their state. They're going to regulate the sale of securities within their state on top of what the federal government does. Now, I've mentioned this before that yes, Reg D offerings are typically exempt, federal preemption, right? They're federally, if you're exempt under federal law, you have a preemption from state law. The part where people get in trouble is that doesn't mean the state has nothing to do in this process, because they do have anti-fraud provisions, first of all. So you can be sued in a state under the state's anti-fraud provision, even though it's federally preempted sale of securities, right? So if you make false statements, a state regulator could come after you, and some are more aggressive than others. And California prides itself on being very aggressive about this sort of thing. I'm on the Attorney General's email list, so every few weeks I get a newsletter, crowing about how they've gone after and gotten some bad guy. So you've got state regulators. Secondly, and this is the bigger one, the state can impose a notice requirement, and it also can impose some limits on things like commissions, on resales, whether you can use state broker dealers, etc. So you do have, even though these might be covered securities, there's still the notice filings is the biggest thing that gets people, because it's so easy now to qualify under a federal exemption, to take your chances on the federal filing and think that you're home free and not even think about the state filings. And as I was telling Bob before we started, I mean, you don't take this seriously. I can introduce you to people that are sitting in jail. That's right, jail, for messing this up. They didn't defraud anybody, they just messed this up. So this is serious stuff, and you got to treat it seriously. So here in California, the exemption we most often rely on is what we call the F notice, the 25102F. And that is a limited offering exemption. It pretty much mirrors the accredited offering exemption, except instead of accredited, it's a sophisticated standard, or on top of it, they have a sophistication standard. Let me put it that way, instead of an accredited standard, but an accredited investor is automatically sophisticated. Let me just say it that way. The tricky part in California is that a purchaser has to have a pre-existing personal or business relationship with the issuer. Now, and have sufficient business or experience to protect their interests. No general advertising or public solicitation. That's the F notice. And then finally, and this is kind of the biggest thing, they have to represent that they're buying for their own account and not with an intent to resell or distribute. So you'll find that in every securities purchase document in California, that language, because that's a rep that they have to make. And theoretically, it's subject to rescission if you don't get that rep. And I haven't personally been involved, but I've heard of cases where investors have tried to rescind because they did not make that rep. I don't know if they want or not. I can just tell you that it's something that the statute requires. And then the F filing, if that filing is not made on time, there's a penalty, and the penalty is pretty high. It's usually around $2,500. So we want to make it within 15 days of first sale. And even though it's hard to do anything within 15 days of first sale, like these Forms D are almost never filed on time, and they should be. But we don't worry that much about it because I've never seen anyone penalized for filing one late. I've seen lots of people penalized for filing an F notice late. California's on the ball on this. The other thing about this is the other reason this should be taken seriously is it comes up as kind of a sleeper issue. We form a company, we're bringing in founders, and we're bringing in participants, etc. And maybe we have non-managerial participants, and we're issuing stock to all these people who are helping out. They're not accredited, right? So we're not under, so maybe we don't get a Reg D exemption on this. And they're not sophisticated. And I've been in cases, it doesn't happen very often, where I said, look, we just can't do it. We cannot issue stock to this person. You're going to have to find another exemption. We just can't do it. And the other exemption we'll find is Rule 701, which I'll get to in a minute. Okay, I want to mention intrastate offerings. I think this is really hard to do these days in the internet age, but it is possible, and I've known companies to do it. That's a sale that is solely, within a state. It's by a company, that's based in the state, and it's making sales and offers. And by the way, offer is the operative word here. It's an offer of sale, not necessarily the sale. You offer to sell something, you're subject to securities laws, only to residents of that state. So just want to mention that it is out there. And these days we don't need it anymore. The Reg D safe harbors are so big that we can easily rely on safe harbors. Now, what happens if we have a sale of securities, somebody buys them, they want to resell their stock? Remember, I mentioned this earlier, we've got resale restrictions. And what we mean by that is typically Rule 144. And that's a safe harbor that allows holders of restricted securities to resell them without a registration. And typically that means that the stock has to be held for at least a year before somebody can resell it. And affiliates are limited in how much they can sell, officers, director, large shareholders. And there may be a form filing requirement. And so that 144 holding period becomes very important. And there are rules around how you calculate that. For example, what happens if you incorporate an LLC? When does your 144 start? What happens if you receive your shares by gift? Do you get the donor's 144 holding period? So you'll see, and usually when we have a secondary sale, the company will say, well, before we're going to recognize that, we're going to have you, either the seller or buyer, go get an opinion of legal counsel, a legal opinion that says that this sale complies with 144. So there is a safe harbor, and it does allow resales, and almost always we're going to comply with that, or the company won't allow it. And this comes up similarly, secondary and tender offers. What's a tender offer? That's where somebody offers to buy shares, or company offers to buy shares back from its shareholders. It could be the issuer, it could be a third party, but oftentimes it's the company buying shares back. Sometimes it's an investor comes in and they want to put money in, and founders want to take money off the table, so they want to buy shares from some of the shareholders. When all of a sudden we got the tender offer rules we have to comply with, and it generally the general idea here is to give all the shareholders an equal opportunity to participate and to get certain information, um, avoid deceptive acts, etc. So there's a bunch of hoops we have to jump through in a tender offer. And this applies more broadly than you might think, even though it is oftentimes observed in its non-compliance, I guess. But it's out there whenever we have an offer. When we have a broad-based offer to buy shares, let me put it that way. And then finally, Rule 701 that I mentioned, I said, what about employees, service providers? You know, you've given me all of these very technical, tough rules. How do we get options to employees and options of security? How do we give stock to people? And that's the federal securities law exemption that allows private companies to issue equity compensation. Employees, officers, directors, consultants, advisors. We have rules around this, as you might expect. There's a limit on how much stock can be issued. And most of the commercial cap table companies now will automatically kind of monitor and calculate those limits. In the old days, we had to do it ourselves to make sure we didn't go over the 701 limits. But honestly, it's hard to do. It's hard to do. You have to be giving away a lot of stock to employees to blow these limits, but there still are limits. And if you sell enough stock to employees, etc., there are disclosure requirements that we have to pay attention to. Okay, and then Reg S, I said finally, but maybe this is finally. Reg S, foreign sales. What happens if we have a sale that is completely outside the United States? Well, then the SEC should care a whole lot less, right? Because these rules are designed to protect U.S. persons trading in securities, buying and selling securities. But we have Reg S, so you know that is an exemption for a sale outside the United States, and that means all the selling efforts are made outside the United States. And I have another video online where I kind of dive deep in this because there's different flavors of Reg S depending on whether it's a US company or a foreign company, etc. But given our time and for our purposes here, I will just say that there is a rule. It requires certain representations, no federal filing, and it does require that you meet certain requirements to fit within this rule and the implementation of some procedures to ensure that we comply with these requirements. But we use Reg S a lot. We use it a lot, they put it that way. Sales to foreigners who are not necessarily accredited. Yeah, I have hours and hours on ICOs online, and in 2018 or so, our new sheriff, the SEC, chased all of these ICOs out of the country. And since then, I think we're seeing them coming back. Even the Bank of North Dakota now has a stable coin. So crypto and those sorts of instruments are coming back. But the general idea for an ICO is that we just bite the bullet oftentimes and say, look, it is a security, so we're going to do the whole thing outside the United States, or we're going to do it accredited only within the United States, or we're going to do it on a platform, many of which have developed an exchange that only allows accredited investors on the exchange. Remember that SEC no action letter I showed you, so that we can comply with all these complex securities laws in either an accredited only environment or a foreign only environment. It's usually one of the two. We talked about what is a security. I don't want to relive it given the timing. I do want to talk about the current SEC guidance on crypto. Because like I say, there's a new sheriff in town, and the SEC as of 2025 has a three-pronged framework for determining whether the securities laws will apply to your token. One, initial sale context, was it marketed as an investment? Secondly, does it have utility on a decentralized network? And thirdly, the degree of control by the founding team over the token and the network. So contrast, like a cryptocurrency like Bitcoin, for example, that's clearly, it's not a security. It's out there. Nobody really has control over it. Contrast that with some tokens, which are really very much like a DAO, what a DAO might issue. That's very much tied to the efforts of the people who are working the product. We've got several cases now that mostly have been pro SEC, SEC v Ripple, SEC versus LBRY. They've reinforced that a lot of tokens are securities based on how they're marketed and used. But the biggest thing is really, are you relying on the efforts of somebody else? Are you looking for an investment return? We've had a big shift in the securities regulation of crypto. The Department of Justice disbanded its cryptocurrency enforcement unit. This is an old slide, old as in a few months, but several crypto cases were just simply retracted. The SEC said we're not going after them. And we've got a crypto task force that is trying to move from what we had before, which was clearly regulation by enforcement, to regulation, by regulation. So we have some rules that we can all apply. And I was part of the attorney group many years ago that wrote up a set of rules for securities laws that should apply to crypto. Every big law firm in town participated in this. And we had a very fair set of rules for regulating the sale of securities. And we sent it to the Securities and Exchange Commission, and they did not care at all. They did not respond at all. Well, now things are changing. We've got an SEC crypto task force that is looking at crafting a framework. And you've probably seen the news about stable coins. But more importantly, you've probably seen the news about the Market Structure Bill, the Clarity Act, which is not yet law, but it's under review in the Senate. It's passed the House. And the Clarity Act would clarify that many digital assets, especially those tied to blockchain, are digital commodities and not securities, meaning that they're in a much milder regulatory environment. So there's a pathway for digital assets to be marketed and sold, but more importantly, that we'll have some actual rules so we have some certainty as to what the law is. So keep an eye on that. That's something that may pass. I know we're a little over time, and I'm going to keep going because there's a couple things I need to say. We haven't even talked about fraud. And there's two kinds of fraud I want to talk about. I write about this at length in my book, my latest book, which I'll advertise at the end of this. But 10b-5, or Section 10b, you probably see these reps once in a while in your documents, and it's basically just a rep that we've given you all material facts. So that is 10b or 10b-5 anti-fraud liability, is the requirement of federal law that we disclose, that the issuer disclose all material facts to the investor. That's both public offerings, private offerings, secondary market transactions. Liability requires proof of intent to deceive. Some other securities law anti-fraud provisions don't require that proof, just negligence or reckless disregard. The SEC can bring these actions, but investors can also sue under this and say, look, you didn't tell me that material fact. I'm rescinding under 10b-5. One step beyond that is common law securities fraud. And in recent news, in March, the founder of Frank was convicted, and just recently, within the last few weeks, was sentenced to 7 years in prison for securities fraud, defrauding J.P. Morgan by inflating the number of users that the company had in order to get the acquisition deal. So, and we all know about Theranos, we all know about FTX, we all know about Nikola. So this is real. And again, I write extensively on the difference between puffing and fraud. And just keep in mind, the bar is low when it comes to securities. The bar is low as to what constitutes securities. And what I always tell people is that you've heard of caveat emptor, buyer beware. When it comes to the sale of securities, seller beware. Especially because of 10b-5, you better have told your investor everything that you would expect them to want to know. How do I know that? I say, did you tell them this? And if you say, no, I don't want to tell them that because that might make them not want to buy my security, that's material. That's how I know it's material. That's a good test. We talked about registration rates last month. I won't revisit it, just to say there are different flavors. And with that, we're only 3 minutes over because of my long introduction. I'm Roger Royce. I'm a partner with Haynes Boone in Palo Alto. I do emerging growth and venture capital. I have 2 books. One is Dead on Arrival, How to Avoid the Legal Mistakes That Could Kill Your Startup. The other more recently written during COVID is 10,000 Startups Legal Strategies for Startup Success. Thank you all for listening. And with that, I am going to conclude the presentation and the recording.